The phone lines are open, and Judge Muriel Robinson joins us now to answer your legal questions. As always, good to have you with us today.
Good to be here.
All right, we have got a host of folks online right now. Lydia is with us. Lydia, you're on the air live. Go ahead, please.
Hi. I was calling about a child custody issue. My son has joint custody for his little girl that's 7 years old, and the mother restrains that visit depending on what's convenient with her, even though it's court ordered. I just wondered what the judge would suggest that he could do legally to change that.
Well, if you have a parenting plan and it's not working, or if you have significant days that you're supposed to visit and she changes that, you need to go by the plan. Now, if you want to change the plan, you have to file a petition before the court to modify it, and it has to be a substantial reason for the modification. Usually, the court will enforce the parenting plan, and the court expects each parent to have the child with them the time the parenting plan designates, instead of, you know, doing it for convenience or whatever. The parenting plan is incorporated in a court order, and it means what it says. But if you need it modified, you file a petition if you can't agree to enter an agreed parenting plan that modifies it.
Okay. All right, fantastic. We have Elizabeth with us right now. Elizabeth, you're on the air live. Go ahead with your question.
Yes. I have a friend that hasn't just learned recently that they have another child, and he's trying to figure out how to get his child. The mother left their child with a friend of theirs, and he just learned for sure that this is his child, and he tried to get in contact with that friend who's holding his child, and he's trying to find out how to get his child so he can get DNA testing.
Well, you would have to go into juvenile court, and he would file a petition to establish paternity. So unless this person that has custody of the child, which may not be legal, it may just be possession, he can file a petition for paternity alleging these facts. Then he has to prove them. If he needs a DNA test, then the court can order that test to determine whether actually he is the parent. But he'd have to go through juvenile court and file a paternity petition to be declared the biological parent. He has to prove that.
All right. Rosalind, you're on the air. Go ahead with your question, please.
Yes, I'm calling, it's concerning bankruptcy. Now, if you're on Social Security, how do you know, as far as the price of paying for bankruptcy and trying to get bankruptcy? Is there a set amount that somebody that's on Social Security has to pay, or is it the same for everyone, no matter what the circumstances?
Well, first of all, you call the Bar Association and get a list of good bankruptcy attorneys. And then you file the petition. A Chapter 7 is a complete bankruptcy, and you'd have some court fees. If you're indigent, you would fill out a form, and they would assess how much you pay, whether they reduce it or not, or give you time to pay it. Now, there's other Chapters 11 and Chapter 13, which are payout plans or plans for corporations, too, that might be in bankruptcy. So you need a good bankruptcy attorney to tell you what you need, whether it's a straight bankruptcy, which discharges all your debts, or whether you intend to pay in installments. And, of course, the court sets that based on your ability to pay. Okay,
all righty. But, yeah, you need to have a good conversation and figure out which of the three is going to be best for you.
Right. Don't go to a divorce lawyer if you've got a bankruptcy case. Bankruptcy for you.
Good. Well, great information. Thank you for being with us today.
Good to be here.
Judge Robinson is here the third Tuesday of every month, so if you didn't get through on the phone lines today, try us again next time.